got 65. And then but my MBAs with that. So I was, and Brian told me he had class. I think it was. Yeah, he told me Saturday.
He told me that too. They told me he considered no. Because he just looked at the stamps and he said, they're so small in their stamps. What do you think about the just if you look at your stats, that's the worst.
So that, yeah, so I looked and I was so then
He doesn't go.
yesterday I went to and I was like, well, I just
You're not complaining.
now.
You know, well, I thought that was a brilliant question. And I found it quite entertaining, even if I didn't catch all the Star Wars references.
Okay.
I'm just sharing. I've seen 5 of them. We have 5 students.
That doesn't leave any for you and me.
I know. Well, we have one. The one that we toss back and forth.
Okay.
I'll make sure that.
We don't need to know evidence.
We don't need no stinking evidence. So are you fully transitioned now to Palm Springs?
I'm not transitioned at all. It won't be until January 7th.
Oh, okay.
4 weeks from yesterday. So was that like truly inspiring, guys? We're all like fired up.
Yes.
And once you take that oath, you can commit legal malpractice. You have to get MCLE credits, all that kind of good stuff. Who wants to do that?
Yeah. So I was.
Now that you say that, I might just leave.
Yeah, right.
So I was. I can always tell you how long I've been a lawyer by how old my kid is, because when I got sworn in, I was holding my youngest, who was a baby at the time, and she's 20. She was born in August. I was sworn in December, so I can always tell you. Well, here's how long I've been a lawyer.
Well, Evans has been a lawyer a lot longer than you have.
So
You said 38 years. Wow. He's got 6 years on me.
a lot.
You never know what to look at him. Look at that black hair. What is his secret?
But your daughter's 38 years old.
Mm.
Your daughter's 38?
20.
No.
20.
Evans
Evans.
has been with me over 38 years. Sorry.
Yeah.
He does have some flawless hair.
Yeah. I'm very happy
How do
to.
you judge us?
Hey, I just got hair. I'm very happy with that.
Yeah, that's what I got hair.
I know.
You know.
I don't give a damn that it looks white. It makes me look old. So.
All right, guys. Couple of things. There are new books for you guys. We're trying something brand new. You guys are the guinea pig. This is a California evidence guide.
More reading.
We've never implemented it into our class until this year. So we're trying.
Look.
I think we need one more, right? Because there's 5 of them. I have one. Judge Hopkins, I have.
Oh, okay.
If you haven't, I don't know if you have another one for me.
No, but I will.
Okay.
Place another order for sure.
Thank you.
So, you know, our hope is that, you know, when we see these books at the end of next semester, they're out of the cellophane and maybe you guys have looked at them a little bit.
And this is a good summary and practice, help you like actually do it in the real world. It's written by is he the dean of the Santa Clara Law
I
School?
think he is, yeah.
Yeah, who Professor Ullman, Dean Ullman, whatever, routinely writes a review of the California Supreme Court every year and stuff like that. He's a widely respected guy, and he does know evidence. You probably saw me with a book by Justice Simon's California Evidence Manual. If you're gonna actually do California evidence as opposed to sort of study evidence for a class like this, I recommend that. It's really good. And it's more comprehensive than this, but this is probably more than adequate for your purposes in this class.
And he was part of O.J. Simpson's defense team.
Hey, who wasn't?
Exactly. That was a lot of defense attorneys.
Question is, did he get paid?
Don't know that.
Yeah, because they stiffed F. Lee Bailey.
No,
Yep. OJ.
Well, he's got no money.
It's shocking that a guy that would kill his wife and another guy stiffed his lawyers.
All right. So tonight is review. We've got a full semester to cover. And our outline is oddly just 5 pages, 4.5 pages. That's all you have?
But what's the key to evidence?
You gotta know these. Let's just, before we get into the essay, let's just go through these real quick. Let's hit the highlights. We're moving. So if you guys have questions, you gotta stop us and tell us, otherwise we're moving through
And if you
this.
think of something when you're studying this week, email us, okay? And if you haven't heard from me in about 12 hours, email me again, because I try to check my email, but I get a bunch of emails in that email box. I have missed it. So email me, email Professor Nolan, and we will get back to you. And if you'd rather talk, email me your phone number.
Okay. General provisions, rules 101 to 106 of importance to you guys, right? 103 talks about rulings on evidence, preserving a claim of error. That's going to be a multi-state type area,
Oh, yes.
right? 104, that's where all our preliminary questions are answered, right? That's where you have a hearing in front of the judge. That's where you come in and say, is this person qualified as a lay witness or an expert, right? Is this piece of evidence coming in or is it not, right? And rules of evidence do not apply in 104 hearings, except for the rules of
Anybody privilege?
privilege.
It was a trick question, wasn't it?
You guys got to know that because privilege will
Privilege
come up
always
next
applies.
year,
Yeah.
and next semester it's going to come up, and you're going to think you know 104, and you're going to forget the privilege part.
Privilege is really important because if you blow it once, you've blown it forever, right? Because then the information gets disclosed. So that's why privilege has to always apply.
105, limiting evidence, right? That's when the judge says, well, I'm going to let this evidence come in, but I'm only going to let it come in for this limited purpose.
So jurors, don't consider it for this other purpose that we know you're going to
So
consider.
you've got to ask, okay, Your Honor, can I get a limiting instruction? And of course, 106 is the rule of completeness, right? If one party puts in part of a statement and fairness, the whole statement can come in, should come in to give it context and real understanding. You've got to ask at the time, and you can get it to come in that way.
Yeah, and heavy emphasis on it. And when does it come in? Along with the rest of the statement that the first party offered.
Yeah. Don't have to wait until your case to offer the rest of it. You can, but if you want it all out there at the same time, you got to ask.
Yep.
Okay. 401, 402, 403. You got to know those, right? Know your rule for relevance, know your rule for balancing, and 402 is just kind of your general, we favor the admissibility of relevant evidence rule. Big area number 1, character, right? It might have seemed like a long time ago, but we did cover character evidence, right? Character evidence is not admissible to prove that the person acted in conformity with their character trait, right? Doesn't matter civil or criminal, can't do it. There's exceptions, right? You've got 4 exceptions. 3 of them have to do with criminal cases, right? Defendant can offer their own pertinent trait in. I'm peaceful, I'm generous, I'm kind, and prosecutor can rebut. Defense can enter into offer evidence of the victim's trait, right? The prosecutor then has options. They can rebut the victim's trait. You say he's violent, I say he's peaceful. Or the prosecutor can say, oh, you say he's violent, well, I got evidence that says you're violent. You can do either or. Okay, and in a homicide case, prosecutor can offer evidence of the victim's character for peacefulness to rebut evidence that he was the initial aggressor. Okay, and then lastly, evidence of a witness's character may be admitted under 607 to 609, and we know that has to deal with a witness's character for truthfulness. Right? You can offer that in if their character for truthfulness has been challenged. Once it's been challenged, you can rebut it. But until it's been challenged, you can't. Okay? So what's the first thing you can do? Offer evidence of somebody's character for untruthfulness. That's the first thing you can do. It's not until somebody does that do you ever get to hear about somebody's character for truthfulness. Crimes and other acts, be leery, be cautious. Don't call this character evidence or you're going to get confused. It's not character evidence. It's motive evidence. It's opportunity evidence. It's intent evidence. It's knowledge evidence. Right? All of those things. Right? Crime or other acts can come in for these isolated purposes. Okay, they can come in their case in chief and they can come in as specific acts. Okay, that's important because how do you prove up character under 405? Reputation and opinion only by specific instances of conduct if it's an essential element of the charge, claim, or defense. Okay, so the only time you can use specific instances to prove a reputation is if it's an element, right? And we talked about the, Bill Clinton sues, says this newspaper said he was a womanizer, and part of their defense is, well, it's true, right? That's an element. So to prove the element of their defense, they can bring in all the specific instances of Bill Clinton's womanizing to prove their defense. If it's not, opinion and reputation only. Habit, right? Evidence of a person's habit or an organization's practice is admissible to prove that on a particular occasion they acted in accordance with the habit.
Ooh, that might apply to Bill Clinton.
Right? So that means if it's your habit, it comes in. It's like, well, wait a second, habit's even more than character evidence. It gets to come in. So what's the difference? Habit is something you do every time. Character is what you do most of the time, some of the time. Right? If you can say this is what we always do, it's habit and it gets to come in. Questions on character? Okay. And then we've got all of our other relevancy type sections, subsequent remedial measures. Right? All of these rules read the same. Are not allowed, right? This is not admissible to prove A, B, C, and D, right? Excellent. Negligence, culpable conduct, product defect, need for warning. But here's the exception. You can use it for all these other reasons. You got to know the distinction. If you just go through each of these rules, you see 408, offers to compromise. General rule, can't use it. There's exceptions when you can. The exceptions under 408 are not the same exceptions as under 407, right? And under 409, it doesn't even offer exceptions. But there are exceptions that we know through case law, but it's not laid out in the statute. So you can't use offers to compromise. You can't use offers to pay medical expenses. You can't use plea bargains. And each one of these has the same public policy rationale underlying it. And that is, we want to encourage these behaviors. And if you knew they would be used against you in court, you wouldn't engage in them. So to encourage these behaviors, we say you can't use them against you in court. And of course, liability insurance is the last thing. Any questions on any of those? No? Good. Witness competency. Right? 601. Who's competent?
Everybody.
Everybody.
Unless.
Unless. Right? This is kind of the inverse rule. Right here, everybody's competent unless, and remember, in a civil case, state law governs on competency. Okay? Civil case, state law governs. So what do you need? Got to have personal knowledge. Except, you got to keep that in the back of your mind, except for an expert witness. Right? You can only testify to things that you are personally aware of, that you personally perceive. Okay? 603, you took an oath. 604, interpreters, right, take their oath, and they affirm to give truthful translations. Judges' competency, they can't testify.
We're incompetent. Wait.
Right? Jurors' competency, they can't testify, except post-trial, they can testify to say, this extraneous prejudicial information was brought to our attention. Okay? So when you're talking about witness competency, just go in a checklist. So I have A, B, C, and D. If we have all of these things there, then they can testify. Doesn't matter. There's no age requirement, young or old. There's no ability to see or hear or speak. Right? If you can perceive and you can communicate that perception somehow, you can testify. Okay? Cross-examination, impeachment. Who can impeach? Anybody. Right? So I don't want to see any answers. We see them almost every year.
No, you can't
This
impeach your own
person's
witness.
impeaching their own witness. They can't do that.
You see that in court a lot.
Yes, you can. You can impeach your own witness. I would encourage you to impeach your own witnesses. Okay? 608, character for truthfulness. Right? We spoke about that a little bit as a general rule. You know, you can offer characters, witnesses character for truthfulness, but only after it's been attacked. So once somebody says this person's a liar, you can come back and say, well, in my opinion, they're not. They have a reputation for being truthful. You can do that. And here's an important thing. When you're talking about witnesses' character, you can be attacking the witness who is testifying or the witness who they're testifying about. Right? So if I come up here and I say, you know, I've known Judge Hart my whole life, and he's as dishonest as they come. Okay? You can come up and rebut that. No, offer evidence that he is honest. I got witnesses that'll say, in my opinion, he's honest. You can also attack me. You can bring witnesses and say, well, we've known Nolan our whole life, and that guy's dishonest.
Yeah.
Right? So both things are fair game. Right? When a character for honesty and truthfulness testifies, their character becomes an issue, as well as the witness they're testifying about.
So if anybody ever wants to call you as a character witness for the truthfulness of somebody else, don't do it. Because you'll get smeared as a liar too.
Yeah, they can attack you, and you can see how this goes, right? In my opinion, he's a liar. In your opinion, he tells the truth. In his opinion, you're a liar, right? And in your opinion, he tells the truth, right? And you think he's the liar, right? And it's just as vicious. Your trials will get out of control very quickly.
Can anybody say 403?
Yeah. So, when do you get to use specific instances of conduct? Right? Well, extrinsic evidence isn't admissible to prove it, so you can cross-examine on it, right? But remember, you're stuck with the answers, right? You don't get to offer extrinsic evidence of that.
And I was thinking about that one is in back to school where the economics professor has accused the Rodney Dangerfield character of cheating or plagiarizing his work, and Dean Martin says, now, Mr. Mellon, is this your work? And he says, Dean Martin, I can't lie to you. Yes, it is. You're stuck with a yes, it is.
Right. Well, that's a federal rule. In California, you have a little more leeway on this stuff. But under the federal rules, you are 100% stuck with the answer. Okay. 609 are criminal convictions. Okay, there's a lot of stuff in here, and you just got to know it. All right, felony convictions. Remember, we're using that term. That's not how the code reads. So make sure in your mind you understand what the rule is. Right, it's a crime that's punishable by more than a year in custody or death, and anything in between. Right, you look to the possible punishment. You don't look to what they actually got. If they could have been punished for more than a year, but they only got 10 days, it still qualifies. Okay? And remember, the rule is it must be admitted subject to 403 for any witness, not the defendant. Okay? Remember how that word the language of the statute read, so the court must subject to 403. So if you want it in, that's what you point out. And the judge will say, well, that's nice. You tell me it must, but under 403, I'm going to keep it out. Okay, but that's strong language. That indicates a preference that this would be used, provided it's probative. Okay, must be admitted against the defendant if its probative value outweighs its prejudicial impact.
Which is different than 403.
It's different. It's more stringent. It's changed the variables. Instead of probative value being substantially outweighed, now the probative value actually has to outweigh the prejudice. That means it's harder to get convictions in against defendants. Okay? And when you're talking about misdemeanor convictions, right, the court has to be able to look to the elements. And the elements have to show a dishonest act or a false statement. If you don't have a dishonest act, you don't have a false statement, can't use it. Then you've got the time component, right? Those rules apply if you're under 10 years.
From the conviction or release from custody, whatever is most recent.
You got that? But you got to look. Well, what were they? When were they convicted? When were they released? Right? They were convicted 50 years ago. Well, doesn't seem like it applied, but they were released last week.
Well, yeah, they were in prison for a long time.
Right? So if you meet the qualifications, if more than 10 years have passed. If less than 10 years have passed, you just use what we've been talking about up till this point. If more than 10 years have passed, you can still use it, provided your probative value, supported by specific facts, substantially outweighs a prejudicial effect. And you've given notice, right? So now it's even greater, right? For defendants, it was just probative value outweighs prejudicial effect. Now it's probative value has to substantially outweigh. So it's even harder to get an old conviction in against anybody than it is to get a under 10-year conviction in against the defendant. And of course, the easiest is against the witness. Okay, you've got to know these differing standards to accurately apply the rules. Then you've got pardons, annulments, and certificate of rehabilitation. Right? If you've been the subject of a pardon, annulment, and certificate of rehabilitation, and kept your nose clean, you haven't reoffended for a year, can't be used against you. Remember, if you have reoffended, then we deem your rehabilitation to be not sufficient, because you've reoffended, and it can be used. If one of those things, a pardon annulment or certificate of rehabilitation or equivalent procedure, found you to be innocent, can't ever be used against you, even if you reoffend again, right? Because you were deemed innocent.
Because you weren't guilty, yeah.
Okay? Juvenile adjudications, hard to get in,
Can't use it.
right? Only in a criminal case, only against the witness, not the defendant, only if it would have been admissible against an adult, which means everything we've talked to up till this point, you have to go through that analysis, and evidence is necessary to fairly determine guilt or innocence. Okay, that means it's got to be highly probative on that specific issue, right? Not on some side issue. So very hard to get a juvenile adjudication in, but you can, provided you jump through all of those hoops. Pendency of appeal. If you're on appeal, that's fine. If you could otherwise use the conviction, you can still use the conviction. The court just has to tell the jury that, oh, this is on appeal, if you ask them to. Okay, you have to make that request. Questions on convictions?
Yeah.
Yeah, you just gotta know it.
For felony convictions again, you said to look to the possible punishment, not the sentence.
Correct.
Can you explain that one more time?
So if
Let's say you can be punished if you're convicted of fraud by 16 months, well, by, let's say, 8 months, a year, or 2 years. Okay? The fact that you could get more than a year is what matters, not what you actually got.
Okay.
You may have pled guilty and had an agreed sentence of 8 months, right? That's not a year. But you can use it anyway because you could have gotten, the maximum was more than a year.
Okay. Religious beliefs, religious opinions, not admissible. Okay, either way, right? You can't say believe this witness because they're a good Christian, and don't believe them because they're not a good Christian, right?
Can't do that.
You can't do that. Religious beliefs and opinions, not admissible. 611 just talks about scope of cross-examination. We've talked about that, right? The scope of your cross should cover what was covered on direct and anything having to do with impeachment. But the court may, in its discretion, grant some leeway if they do. Okay, leading questions, use them on cross, don't use them on direct unless you're laying some sort of foundational type issue or you're dealing with a hostile witness. Big topic number 2, I guess you could say 3, right? The impeachment's kind of, the conviction stuff is kind of messy. Once you know it, and it's pretty simple. Okay, it really is, and it makes sense the way they're graduated. But then we come to opinion. Right, the first one is lay. Right, lay witness is not an expert. Right, and there's 4 criteria. Right, it's got to be rationally based on their perception. It's got to be helpful to the understanding of witness's testimony. Can't be based on scientific, technical, or other specialized knowledge. Right, there is no rule, right, for a skilled lay witness, but there is such a thing. Okay, so what differentiates a skilled witness from a lay witness? They have some specialized knowledge that doesn't rise to the level of an expert, right? They may not even be an expert, but they know something more than the rest of us. If it's something that every common citizen would know, or most citizens would know, probably qualifies as a lay opinion.
Like estimating the speed of a car.
Right. If not, then you got to look for something different. Okay, so yeah, the example that we went through for the skilled was like a police officer, right? Can a police officer tell you about gang graffiti? Sure. Can they tell you what drugs look like and how they're packaged? Sure. Do most people know that? Hopefully not, right? Maybe they do. Maybe a layperson can't answer that question. It's going to depend on what their foundation is, right? What can you pull out of them, right? If they can identify a basis of knowledge short of being an expert, they may still be able to give you an opinion on the matter. Okay, I've been using crystal meth for 20 years. I know how it's packaged. I know what it looks like. I know what the symptoms are. I've seen people on it. You know, you ever been to school on drugs? Nope. Right? You ever had any specialized training? Nope. Okay. Can you give an opinion that I think this was meth? Probably. Right? I got 20 years experience on it. So, if everybody would probably do it, lay opinion. If you've got some specialized knowledge, not rising to the level of an expert, skilled lay.
So would an example of a skilled lay be like a police officer?
Yes. Yes. Right. They have some specialized knowledge, but they may not even be like you could bring an officer in and he could tell you, I think this is meth based on what? Based on my academy and my 1 day on the job. Right. I've been trained on this. Are you a drug expert? Nope. Are there drug experts who are cops? Yep. Now, they got a lot more experience and a lot more training, and they have to articulate that, and the judge makes the determination whether their knowledge and training and experience is sufficient to make them an expert. Okay? But they may have some specialized skill or knowledge about a specific topic that most of us wouldn't have, then they can qualify as a skilled lay. Okay? And then you get into experts, right? They got to be qualified by their knowledge, skill, experience, training, or education. You don't need all of them, but you need at least one of them. Okay? They get to testify in the form of an opinion if their expertise will help understand the evidence or determine a fact and issue. It's got to be based on sufficient facts and data, right? It must be a product of reliable principles and methods, and then you must have reliably applied the principles and methods to the facts and the data, right? So it's got to be helpful to understand. You got to have facts and data, reliable principles, and then put all that together is the last part. Okay? And then you can give an expert opinion. Right? And who decides that? The judge. Do they need personal knowledge? Nope. What do they rely on? Things that other experts would rely on in examining this area and coming to the same type of opinion. What do you need to come to this opinion? I need A, B, and C. What would some other expert need to give an opinion on this? Well, they would need A, B, and C. Right? So provided you've got these reliable principles underlying whatever they're giving their opinion on, any expert would need the same type of information to come to their same conclusion. Okay? Doesn't necessarily have to be the same information. It just has to be the same type of information. 703, the bases, right? It's got to be based on facts or data in the case that the expert is aware of or personally observed. Okay, here's where you get into trouble with expert testimonies, right? Whatever facts you're feeding them to form the opinion ultimately has to be in evidence. If you don't get those facts into evidence, right, I'm going to stand up in my closing argument. You know how good that opinion is? Not very, right? You can take that and throw it out because what did he base it on? He based it on this fact, this fact, and this fact. Any witness ever come in and give those facts to you? Nope. So what's it worth, right? So whatever they base their opinion on, at some point that has to be in the case, right? They don't have to be the witness that puts it in the case, but it's got to be in the case. It's got to be facts and data that other experts would rely on. And if the facts or data is otherwise inadmissible, it can only be disclosed to the jury if probative value substantially outweighs their prejudicial impact. Again, this is an inverse 403. Okay, so you've got some data, right? Just to kind of keep it simple, I've got a gang expert, and I want him to give this jury the opinion that the defendant is a gang member. And what are you basing your opinion on? All of these facts. One of these facts is this defendant admitted he was a member of this gang. But the court has ruled that statement was involuntary. It's not admissible. That's a pretty good point that my expert wants to rely on to say he's the gang members, that he admitted it. So if it's not admissible, can it be disclosed? Can you tell the jury, where I relied on the statement by the defendant where he admitted? Yes, if its probative value substantially outweighs its prejudicial effect. Who makes that determination? The court. Can a court say this is inadmissible evidence in this area? However, I'm going to let it in over here. It can. If they've kept it out, it's probably pretty prejudicial to begin with. So good luck getting it in over here. But in theory, you can. Okay. So just know that that's a different standard, and it's a reverse 403. Opinions on the ultimate issue, general rule, they're not automatically objectionable, but in criminal cases, they're not admissible, right? You don't get to come in as an expert and say, do you think this guy's guilty? Nope. Right? You don't get to give an opinion on the ultimate issue. You can get close, right? You can give opinions on mental states and things like that, the ability to form intents and things like that, but you don't get to give a statement on the ultimate issue. Okay? Disclosing basis of expert opinions. Experts can give an opinion and a reason for it without stating the facts or data it is based on. Or on cross-examination, they may have to disclose the facts or data. That's a frustrating rule. It makes sense, but it can be difficult, right? So this person says, I formed this opinion. What did you base it on? I reviewed this report, I reviewed these tests, I reviewed these witness statements, and I conducted my own tests. Okay, and here's my opinion. Short, sweet, flows, makes for a very nice direct, right? And then you want to cross-examine it. He did tests. Do you have those tests? Nope, he hasn't disclosed them yet. Right? They're not obligated to disclose them. So what do you say? I want to see your data. And where are you telling him this at? On the witness stand, in front of the jury. How does it look? Messy, right? He looks bad because the expert looks like they're hiding something. You didn't turn this over before. You look bad as a lawyer because he's giving you data and you think you got the smoking gun and you're trying to look at it and the court saying, counsel, move along. And well, I just got this. I want a chance to look at it.
This is why civil is so much civilized.
You know, it can be a mess. So, and you know, we give you that warning. Don't ask questions that you don't know the answer to. Well, if they say I based on these things and you don't know what those things are and you ask, they can bolster that opinion and hurt your case. Right? So you got to have a pretty good idea of what you're getting into before you go down that line. Okay. And court-appointed experts, yeah, be familiar, know that they cut and paste. There's some really good court-appointed experts, but I've seen some that, okay, you didn't even change the name, right? you're doing John Doe's and this says Steve Johnson on it. Didn't you do Steve Johnson's report last week? But you don't need to worry about that. Questions on the experts? All right. That's it. That's all the rules you gotta know.
I have one question. We can go back to 608 real quick.
Okay.
So evidence of truthful character is only admissible after character has been attacked, but then you said you can attack the witness and the character of the person the witness is testifying about?
Yes.
Is that correct? Okay.
Well, you can respond to both, right? So a witness testifies, the attacker has to come first.
Right.
Right? You don't get to call somebody and say, hey, well, that person you just heard from, yeah, they're a real
He's
honest
really
person.
truthful, yeah.
You can't do that. So the person can come in and say, in my opinion, this person's untruthful.
Then
You can attack both. You can bring in somebody to say, well, I find them to be truthful. This witness that you said is untruthful is actually truthful. And now I can attack you and say, well, I've got witnesses that say you're a liar. Right? You can do both. Kind of like when in a criminal case where the defense says victim is violent, the prosecutor can do both. The prosecutor can say, well, I've got witnesses that say the victim was peaceful, but I've also got witnesses that will say, defendant, you were violent, right? And you can do both. So when a truthfulness character witness comes out, you can attack the witness and the witness they're testifying about. You can do both. Okay, and that's why you can see how that can spread very quickly, because then those people, you can attack them and vouch for them, and it just multiplies out.
no, it don't. Because you get a Rule 403 objection, you say, oh, we're screwed around. We're wasting too much time, we're confusing the jury.
So if there's someone that testifies that says like somebody's arguing self-defense and he's saying that the victim was violent, what if, does it change if the victim is dead?
Yes,
Yes.
That's dead.
if the victim's dead,
All you can do is offer evidence that they're peaceful.
Okay.
Okay, that's the homicide case,
That's,
right? If you say it's self-defense, he was the initial aggressor, he's not there to testify in his own defense,
he's
so
dead.
you can offer evidence to show, well, he's got a peaceful character. Okay? So. And notice that doesn't have to be in response to character evidence, right? The defense doesn't have to offer evidence that the victim is violent. They only have to offer evidence that the victim was the initial aggressor. There's a difference.
So somebody says, I saw the dead guys take a swing at the defendant first. Okay,
That opens the door.
now the prosecution can introduce evidence that the victim was peaceful.
But in a non-homicide case, the defense opens the door by bringing somebody who says, I've known the victim my whole life, and in my opinion, the victim's a violent person, right? That opens that door. If you did that in a homicide case, that would still open the door, okay? But you don't have to do that in a homicide case. You just have to suggest that they're the initial aggressor. Yes? Okay. You guys have fun with Star Wars?
Anybody like Star Wars and pick up on all the references here?
Yep.
Yeah.
Okay. By the way, Professor Nolan gets full credit on this because he spent a lot of time doing it.
That is one that we, unfortunately, however clever we thought we were being, we can't use. But I think it's still a good example for us to review with, because there's a lot here. Okay, anybody try to answer it, or did you just read it?
Answer it a little bit.
Okay. So, let's go through it. Let's try to highlight, the question, identifying the issues as we go through, right? In a civil suit, right there, highlight civil suit, okay? From a galaxy far, far away. One that relies on the federal rules of evidence, right? You're highlighting that, right? Princess Peia is seeking damages from Darth Vader for the destruction of her home planet, Outer Law. So you've got a civil case for damages here. Okay, and then we talk about Darth. He's an Imperial leader with vast army of stormtroopers. He was once a Red-Eye apprentice under the tutelage of Red-Eye Knight Obi-Wan Kenobi. As a Red-Eye apprentice, he lived a monastic lifestyle and engaged in many charitable works. His reputation and integrity were beyond reproach. Right? I'm highlighting this. Sounds like character right here. Okay, you don't know if there's a character question down here, but that sounds like character type facts, right? When it starts talking about his reputation. After being seduced to the dark side, Darth has engaged in many questionable and violent acts, right? So that whole paragraph, if you take anything away, those are character type facts, right? Do you guys see that? So at the time of the incident, Darth's Imperial army was at war with a rebellion being led by the Red-Eye, a religious order built on a belief in the source. Red-Eye were trained from a very early age in the ways of the Red-Eye. The training took place in temples, were conducted by Red-Eye masters. Once training is complete, an apprentice becomes a knight, and Red-Eye knights lead the rebel forces on the battlefield. All right, what are we talking about here? There's a little bit of religion there, a little bit of training. Or is this going to come into play about whether somebody's been trained or how they've been trained as to an opinion given? You know the rules that we're going to test on. So you got to be able to kind of see where are these facts going to come into play. And if you're just writing along the edges, this looks like character, this looks like, maybe opinion type facts. Princess Peia alleges that Darth kidnapped her, took her aboard his space station, the Death Moon. The Death Moon is actually one large weapon capable of destroying entire planets. Once aboard the space station, Darth threatened to blow up Peia's home planet unless she disclosed the location of the rebel base. Peia claimed she provided this information, but the Death Moon fired and her planet was blown up anyway. Okay, that's kind of the whole fact of what happened, right? She says he blew up my planet. He says, give me the information. I gave it to him. He blew it up anyway. That's why he owes me, right? He blew up my home planet. Darth denies that he ever pushed any buttons to fire the weapon, claiming it must have gone off on accident. And after the incident, Darth installed a fail-safe firing mechanism, preventing the Death Moon from firing without a complex series of commands. He also purchased a liability insurance policy. Right, you got a lot here. Right, you've got his defense of accident. You've got subsequent remedial measures. Right, you've got liability insurance, and you're just checking those off. Okay, those are things I'm gonna probably want to talk about. Have I seen a question yet? Nope. But like I've told you, when you get to these types of questions, we're going to have to give you the facts. We can't test you about liability insurance unless we tell you somebody's got liability insurance, right? We can't test you about, subsequent remedial measures unless we tell you somebody took subsequent remedial measures, right? So the facts will lead you in your analysis. At trial, the main issue becomes the working of the Death Moon and its firing mechanisms. Experts are expected to be called on both sides. Okay, so what's the main issue? The firing mechanisms of the Death Moon. What do you anticipate hearing? Experts. So what are you going to be analyzing? Probably expert opinion, right? And you haven't even read a question yet, but you already know that. You've already identified, right, some character, some religion, some opinion, you know, the basis of the claim and the defense, subsequent remedial measures, you know, liability insurance, and now I know I'm going to have to be focusing on experts. Okay, you should already, your mind should already be thinking in that way. So, Paya seeks to call Obi-Wan Kenobi, a red-eyed knight, as a witness to the Death Moon's layout and its inability to fire accidentally. Prior to her kidnapping, she was able to download a blueprint of the Death Moon into a droid unit, R2, UR2. Kenobi was able to pull these blueprints from R2 and study them. Darth objects to Kenobi being called to testify as to this topic, claiming he's not qualified. So, number one, what must Paya do to qualify Kenobi? Right, what do you do to qualify a witness?
Show that they're competent.
To who?
Yeah,
Right?
in a 104 hearing.
Right? You have a 104 hearing. You bring the witness in. The court then makes that preliminary determination as to whether this person is qualified and what are they qualified to. So, what do you got to do? You bring the qualifications to the judge. You don't do this in front of the jury. You have a 104 hearing, and the judge will make that determination. Okay? So what, if anything, does Kenobi qualify as? You know what she wants him to say? She wants him to say, I've reviewed the blueprints of this, and it's impossible for it to fire accidentally. Okay? So, you got a lay opinion. You know what it takes to be a lay witness, right? Would most of us be able to look at blueprints and tell you, oh yeah, this thing can't fire with accidentally? No, probably not, right? How about a skilled person? Could a skilled person do this? Maybe, right? Do you have training in blueprints? Right? Do you have training in weapon systems without necessarily being an expert? Maybe, right? So you have those types of things that you want to start analyzing, right? What does Kenobi have? What do you know about Kenobi? You know, he's a red-eyed knight, right? And what does it take to be a red-eyed knight? Right? Well, you're trained from a very young age. Right, you're trained. You live in monastic lifestyles, right? You are trained in temples, right? Once your training is complete, you become a knight, and then you lead forces on the battlefield. So presumably, your training involves some type of warfare. Does it involve weapon systems? We don't know. Doesn't tell you. What if it does? Well, depends on if Kenobi says that. Look, I'm a knight. I lead forces. Of course, I know about weapons. Right? Well, maybe the court finds enough. Right? So it's really going to depend on what it is that he would qualify as at this point. Would that be enough to make him a lay witness? I mean, a skilled lay, right? If you say yes, justify it. Yeah, I think somebody who's maybe been through basic training in the Army can testify about, you know, their rifle, right? Because they get trained on their rifle. Are they an expert in that? Nope. Are they a firearms expert? Nope. So if you think what has been given to you leads you to that qualification, then you say it. If you think he needs more, then say, no, I think he needs to be an expert. Well, what does it take to be an expert? Training, knowledge, experience. He's been training his whole life, right? What would an expert rely on in forming this opinion? What if they rely on blueprints? Does that seem like something they would rely on? Maybe, maybe not. So this is really for you to analyze, to come up with, does he have sufficient expertise to allow him to say what she wants him to say? And you need to follow the rule and see if the facts are sufficient to get you there. Okay? When it says, what if anything does cannoli qualify as, you should go through the analysis of each. Okay? That's not a, oh, I think he's a lay opinion and I'm done. Right? That's a, what do you think he qualifies as? Evaluate each one. I think, because a lot of times an expert may also qualify as a lay person. Yeah, this is somebody everybody knows, but hey, it's also something I know, and I'm an expert in this particular area. Okay, so they may qualify for more than that. And what should he be allowed to testify to? Well, it depends. Did you qualify him as something? If you did, would he be allowed to give his opinion on that? Right? For my analysis, I make him an expert. Like, come on, he's Obi-Wan Kenobi. Of course he's an expert, right? And as an expert, I'm going to say yes, that he gets to testify that he knows how to read blueprints, and he read it, and a death moon cannot fire accidentally. Okay? Of course, you have everything else that we've talked about that you should be considering and throwing in there that are part of every question, right? Is this relevant? Is there a 403 objection? Is this, all of those things come into play, but, keep that in mind as you're doing your analysis. Okay, and watch the questions. In this particular question, there were 3 sub-questions contained in one. Okay, so this is just a classic opinion question where you got to go through, what is he, and what can he testify to? Okay, and you got to know all the rules to properly evaluate. And what is the answer? You tell us. How did you come down on it? Okay, if you said that I don't think that the red-eye night training is sufficient to lead to the conclusion he can read blueprints on this, okay, there's nothing wrong with that. It's just we need you to explain that through the rules, how you came to the conclusion that it's not qualified. Questions on part 1? Everybody gets it? Simple, just go through each of your opinion rules. So now, assume that cannoli is allowed to testify about the firing mechanism of the death moon. On cross-examination, which of the following areas are appropriate grounds of impeachment? You're going to have to go through each of them and explain why, and if appropriate, how you would impeach. So as a juvenile, he stole a pod racer.
This is easy.
Right?
It's not a criminal case.
You see that? So that's what you should say. 20 years ago, cannoli killed Darth Maul.
Ooh, that sounds like more than a year.
Yeah, he cut him in half.
That sounds like potential punishment for more than a year.
Right? This crime was punishable by death. However, following his conviction, he appealed to the Red Eye Council, who held a hearing and concluded he acted in self-defense and defense of another and was factually innocent.
Oh, is that a tribunal that can determine innocence or pardon or something like that?
He never served any time. So, as you go through that, you got a conviction for a felony. It's punishable by death. It's more than 10 years, right, since the conviction and date of release. He's a witness, so you're just using a 403 analysis. You're not doing any sort of modified. He's a witness in the case. And oh, by the way, he went through this process to be found innocent. Well, the rule says a pardon, an annulment, or a equivalent procedure. Does this qualify? You tell us. Does it? Right? I, in my analysis, said it did because it held a hearing. It considered specific defenses, and I said since that served as their basis, it qualified. Does it? Well, the statute doesn't tell you what a equivalent procedure is, right? So if you know the procedure for how you would get an annulment or a pardon, right, you would have a hearing and you would produce evidence, and maybe that includes the evidence of your innocence, maybe that includes the evidence of a defense, and that board or tribunal or whoever's making that determination considers that and makes a finding. Okay, is this equivalent? Yeah. Okay, maybe. Right, I say it was. Right, and I say so it's not admissible. So right now you got a pod race thief who killed somebody, and you're not going to be able to use either of that. Okay. Cannoli trained Darth Vader as a Red Eye apprentice when he was younger, before Darth changed to the dark side. Can you use that? Can you impeach him with that? Yeah, you're shaking your head. And what would you be trying to get out of it?
You could use to show bias.
Sure. Right, you trained him his whole life and he changed on you? You didn't like that very much, did you? You're not a fan of his now, are you? Right? Yeah, you can use that to try to show his motive or bias in testifying. Okay, about 10 years ago, Cannoli lied to the Imperial Stormtroopers, claiming these aren't the droids you're looking for, when in fact they were the droids they were looking for. So now we've got a liar. Does that matter that it was 10 years ago?
We're not talking about a conviction.
No, right? Doesn't matter. That's kind of a red herring that's thrown in there, right? You got to be able to recognize that. It doesn't matter. This is a prior specific act of dishonesty. Can you ask him about it? Can you ask him? Do you lie to those stormtroopers? You can, right? And what are you stuck with?
I did not.
His answer, right? You can't bring in extrinsic evidence. But I've got a video that shows you doing it,
Yeah, too bad.
right? Well, yeah.
Well, let me show it to you to refresh your recollection. Oh, no. Recollection, it didn't show you don't have a recollection. So,
Right?
No, I didn't do it.
So his prior act of dishonesty, yeah, you can use it. You can question him on it, but you're stuck with the answer. Okay? And lastly, Cannoli has been in multiple fights with Darth Vader, including one where he cut Darth's legs off. Cannoli offered to pay for Darth's medical expenses afterwards. Can you use the fact that they've been in multiple fights, including one where he cut his legs off?
That sort of goes to bias, huh?
All right? You guys see that? Yeah, you guys really don't like each other. Like, you cut my client's legs off.
It was his other arm too.
Right? Yeah. Right. You really don't like it. And what about this offer to pay medical expenses? Does that mean anything?
Yeah, you can't bring it in.
You can't bring it in. Why? I want you guys to see it. Why can't you bring it in?
Because it's evidence of promising or furnishing to pay someone's medical expenses.
There's no evidence of guilt or.
Oh.
See, this is kind of like the 10 years from above. Right? You can't use it if Darth was suing Cannoli for his injuries. Right? He's not a party to this suit. So it's irrelevant that he offered to pay. Now, if Darth had sued Cannoli and said, hey, you owe me for my legs, you could not use the fact that cannoli offered to pay his medical expenses. And that's where the public policy considerations come in. But I want you to see here, it doesn't come in because it's irrelevant, because he's not a party to this suit.
Now you could try to argue that somehow, because of, cannoli offer to pay, it shows that he really isn't biased and he's really being fair to Darth, or, whatever. So, I mean, if you said, well, it's really marginally relevant, you can make an argument about that, but it's the slimmest of relevance. But recognize the rule doesn't really apply, right? The rule that says you can't use it, 409, right? Can't do it. That doesn't apply.
Okay. Questions on impeachment? So we've covered opinion, we've covered impeachment. What do you think's coming up next? Right, this is the final, this is cumulative. We got the trifecta of big issues, right? So what's coming up next? Character, right? Yeah, and you know it and you haven't even read the question, right? Paya next would like to call Yoga a red-eye master. Yoga would testify about the power of good and truth in the source and how he can sense that Paya is strong in the source, while seduced by the dark side, Vader has been. Right? Should Yoga be allowed to testify to these issues? Right? Is it saying character? In a roundabout way, it's not telling you, hey, Yoga wants to say, that Leia is, that Paya is truthful or good. He's going to talk generally, Well, she's strong in the source, and the source is good and truth.
Yeah.
And Vader, he's dark, right? So, that should be a pretty simple one, right? It sure screams of character. Okay, can you use character? No. If you say that he's trying to say Paya is truthful because she's strong in the truth, can you do that? Nope.
Has her reputation for truthfulness, or her truthful character been attacked? Not reputation, truthful character been attacked? No. So you don't get to bolster it until it gets attacked.
Right. So and likewise the same thing about Vader. He's saying, right, seduced by the dark side, and that's not even talking about just a foundation that's going to be needed.
Yeah.
Right.
Yeah.
He's saying he senses that Paya is strong. Does he know Paya? Well, nothing in the facts have told you that they've even met. Right? Does he know Vader? Right? Is he going to be able to come in and say, yeah, I know, and here's my opinion of them is this, or I've heard about them, and so, their reputation is this. Right? You need that additional foundational fact, and so if you were going to go down there, just remember everything that's required for that. And in the second part, what if Yoga seeks to testify as to the power that Darth Vader possesses in the source? Specifically, the ability to move objects without touching them, giving Darth Vader the ability to push a button without actually touching the button. Yoga is familiar with an incident where Paya saw Darth Vader choke a man and lift him off the ground without ever touching him. Should Yoga be allowed to testify to these issues? Explain. Right, so that's kind of a combination thing. Right, the first part, should he be allowed to testify that Vader possesses this ability to move objects without touching them? Right, this is where the class went off the rails. Well, you're just going into La La Land. Am I? Right? Let's say I see somebody, right, walk up to Trish, reach up to their ear and pull a quarter out. Where the hell did that quarter come from? I don't know. But I saw it. His sleeves were up, his hands were empty, and then doves went everywhere. Can I testify to that? Of course I can. Right? If
you should personally observe it.
If I perceived it somehow, I'm competent to testify to those things. has he perceived these things? Well, we don't know. The facts don't tell you if he has or not. It tells you specifically he's aware of something that Paya saw. So can he talk about the choking?
He didn't see it, right?
He didn't
He's
see
aware
it.
of it.
Right? He didn't see it. So this is a little bit of witness competency, right? It doesn't matter how outlandish the testimony, if a witness is going to take the oath, get on the stand, and say, here's what I saw. I saw little green men come out of a spaceship, you know, and okay, if that's your testimony, you get to say that. So assuming that Yoda is aware of this and he can testify to this, right? He's a master. You've got, you know, Vader used to be an apprentice, and at night he was trained. Has Yoda crossed paths with him? Does he know this? Maybe he does. Okay? The facts don't tell you that. But the facts specifically tell you he can't talk about the choke lift.
Because Leia saw it.
Okay.
Sorry.
So, in defense, Darth Vader testifies on his own behalf and puts forth his defense of accident. He then seeks to call his boss, Darth Hideous, to testify as to Vader's reputation for truthfulness. Will he be allowed to do this?
Has his reputation been attacked? We don't know.
No.
Where does it say that?
Yeah.
Oh,
Right?
If his reputation's been attacked,
But what you can't do is testify and then call the next witness, hey, that guy,
who just said, yeah,
testified?
sure, yeah.
he's a truthful guy. Right? Can't do that.
But if his reputation for truthfulness had been attacked, then you could call.
And you can't. Right? So explain the rule for that. You can't offer this unless it's been attacked. If it has been, okay, in likelihood it's not going to be attacked until you testify, right? But this doesn't tell you if it's been attacked. So you got to know the rule, and then by knowing the rule, you can answer the question appropriately. Any questions? You got that? Okay. Now I just want you to put your thinking back. So there's no right or wrong answer to this last question, but it gave people fits. They were so mad at this last question, and I didn't understand it. Okay, now you're defense counsel, right? You represent Darth, right? You know his defense is accident. Okay, you know what the plaintiff's case consists of. Who you want to call? You got 5 witnesses. That's all you can call. Who are you going to call?
Ghostbusters.
Manufacturer of
It's
the
a-
fire gun.
Sure, right? You're going to call the manufacturer of the firing mechanism, right? You're going to call maybe an expert who came in and did an analysis after the fact and found a defective part or something, right? You're going to have to call Darth because he's the only one who can put his defense on, saying, I didn't do it,
I didn't touch anything.
right? Who else you want to hear from?
Stormtroopers.
Sure, stormtroopers. Right. And what are your stormtroopers going to testify to? What honest and peaceful guy he is? I don't know. But see, this was just,
This was used.
we wanted you to start thinking like a lawyer. If you wanted to prove this was an accident, how would you go about proving it? And 5 witnesses or less. Right? Maybe you call stormtroopers that were there. Right? Maybe you call the guy, well, I don't know if you've seen him, if you've seen the movie, right? We've seen the guy, they got the big black mask and you can't see their face, and they're the ones they pull the lever before it fires, and maybe you call the firing guy. You're in charge. Who fires it? I do.
Did you fire?
Did you fire it? Nope.
And you saw Lord Vader?
Right.
Did he ever fire?
So it's just to try to get you start thinking like a lawyer, and you know, put some thought into it. Yeah, there was no right or wrong. They're just like,
Yeah,
we didn't cover that.
Yeah, parents, apparently students didn't like being told you can use your imagination to make up facts.
So, that's the type of, we don't do that anymore.
Yeah, we're not gonna ask them to make up facts.
Yeah, we're not.
Do not make, if you think we're asking you to make up facts, reread the question.
Don't do it. Okay? Questions? If you see a question, a multi-state, and it sure looks like hearsay, the answer is hearsay. Pick it,
Even though we haven't covered it yet.
right? Even though we haven't covered it, pick it, right? And then we'll call it even, right?
Yeah.
You all got one extra point for your enemies right now. Right? If you see a hearsay question, pick it. You know it's the right answer. But only one.
Now everybody's thinking
But only
that.
one.
Oh, so that's so bad, George, you'd be like, there are two. There are two. What the hell?
There's only one question where hearsay's an answer. If
Is
it's
it really
there,
hearsay then?
It is. It's the right answer.
If you didn't just say that, I wouldn't have picked it again.
Yeah, I probably wouldn't.
That's why we're
Like,
telling
no,
you.
we didn't cover your, it's not there.
That's why we're telling you.
So you said that you can't talk about a person's character unless the reputation.
Character for
truthfulness.
truthfulness.
For truthfulness.
So so what you can't do is call Professor Nolan, right, as a witness, and then call me to say, I've known him for years, he's really honest, he's really truthful, you can believe him. Unless, in between, somehow his character for truthfulness has been attacked.
Okay.
Okay? Otherwise, you just,
Otherwise,
your
it'd be just
trial's
like,
gonna take
everybody's
forever.
bringing in everybody to swear that the last guy told the truth.
And it's just one big vouching contest.
And then it's like, who's got the most friends that will say that they told the truth?
Yeah.
And of course, even if his reputation for truthfulness is attacked, what do you got? Rule 403, we're not bringing in endless rounds of witnesses to vouch for everybody. But that's the rationale. You can't bolster your witness with somebody saying they're honest and truthful until somebody attacks their honest and truthful character. This is easy.
That's the question? Yeah.
Yeah.
See how we did? We just answered an essay, went through the outline, hour and 15 minutes. So you guys will be done with your essay and your multi-states in hour and a half tops. Right?
And remember the basic psychology of the multi-state, right? Two answers are obviously wrong, and two answers aren't quite right. That's often how they do them. So you got to pick the one of the two that's better than the other one.
And if it says you must and you shall and you
Yeah,
have
be
to,
really wary of that. Be
be
really wary of must and shall.
And the standard of, the burden of proof is always preponderance, is it?
mostly preponderance, yeah. Okay, if it's a decision that the court is making, it's a preponderance. Okay, if it's a question that a fact that the jury will have to make, then it's, is there sufficient evidence for them to conclude that? Okay, those are the two main ones.
I'm glad I didn't get this question because I would get caught in the weeds.
Oh, yeah.
Yeah.
You would
Yeah.
not be alone, so.
And I thought I was being super,
Oh,
Super
obviously
funny
you put
and
so much
clever.
time in this and right.
But
Yeah.
if you
Yeah.
know, if you've seen the movie and you know it kind of well, I think it would hurt you more because you'd be explaining too much.
Right.
And that's where I see myself getting caught in the weeds, is just explaining too much and losing time doing so.
But having a good time, well, no, not really.
So now, now you got Pauline
Yeah,
and
now it's like way
Dave
more boring.
and Wilma.
And big.
And Vic, right?
Vic gets victimized a lot.
So not nearly as much fun, but hopefully it makes it easier for you. I could tell you when we start drafting questions and whatnot, it's not as much fun. These are boring, but okay. Let's stick to real life.
No imagination.
So, what are the questions?
So remember, don't hesitate to, if something's not clear, I don't want you like freaking out and not figuring it out, email us. Because often the answer is like, oh, yeah, duh, right?
Yeah.
But you're just not seeing it.
Yeah, sometimes it seems easy, right? When we tell you, it's like, oh yeah, okay. And then when you see it, you don't get it. Right? We want you to get it so that you'll get it when you're answering the question. If you don't understand it now, you're not going to understand it in the question.
And of course, remember, all the stuff that we covered this semester could be on the final in 5 months, 6 months.
Sure. Yeah.
Right?
We are all.
So don't do like a brain dump when you get to the end of the final.
Yeah. Yeah, you got to hold on to this stuff. Okay. That's all we got. Don't study these books for the midterm. That's next semester. For the final. Just take them with you now so you have them for next semester. And
there is stuff in there like about character evidence and whatever. But I think if you stick to the stuff that we already went over.
All right. That's all we got for you guys.
And of course, this is California, so all the rules and numbers are different.
Yeah, and remember, if you're gonna use a number, go
Make
ahead.
sure you use the right number.
Use the right one. All right.
So, I unfortunately am giving my exam to my paralegal students at this time. So what Irene's going to do is scan all of the essay answers and email them to me, so I can read them over the weekend and get the grades to her by Monday.
Perfect. Well, Miss Karina is proctoring all day, so
Come on.
I'll
I guess you'll be here too.
I'll be here all day.
Excellent.
I'll be grading while she's proctoring.
Hey, that sounds good. All right, see you guys.
Thank you so much.
Have one to your friend.
Thank you.
There you go. You guys can be wizards too.
Yay!
How cool would it have been to have Harry Potter final exam?
Oh my gosh.
Oh my god, yeah.
We could all be evidence wizards.
Evidence wizards, I like that.
All right, yeah.
Thank you.
I see Saturday.
No, you're right. If I would have had a Harry Potter question, I would have gone.
Yeah, you get caught, dude.
So I'm like, no, Harry would not do that. That's not his character.
Just that first part of the question, there were 8 issues. Because we didn't really talk about
Was it today?
I put witness competency, for personal knowledge, 602, you know what I mean, on top of 104, then your lay, your skilled lay, your expert, I feel like that question, there's no way I can get that done in an hour.
I know.
No way. And that's how I felt actually when we had looked at, right for midterms, when we had the review for the midterm. See,
I don't know how we got up to do that. It was
yeah,
like 5.
yeah, but it was shorter.
But it was shorter, like the
fence.
pattern was like this long.
Yeah, I remember.
Yeah.
And I feel like,
So, but we could come and face this on like
well, that's the other thing too, it's like, we're gonna put 401 and 405.
Oh, I bet that's how it's.
Pretty on everyone, but it
No.
takes a while to, you just copy and paste it and then change around the facts.
Yeah, because you can. I'm gonna be like, how he says they just. And they're like, wait, you're talking about ours now. Oh, I downloaded.
That's super bad headache. That one all day, won't go away.
You still wanna join us?
I bet you don't play it once now because I didn't.
I only got the beta bar once, so.
Yeah, what does it say? Word,
Oh,
well,
answer
because it's
phone.
like.
Yeah, right,
I don't know how
That's
to
a
do
weird
that.
circumstance.
What does yours say? What
I don't know,
does
maybe they have some here. Fuck, I can't even put on my glasses. My personal head.
Yeah, I can get that.
So I'm still back. Like, dude, it's gorgeous, we find out Monday. Well, by Sunday, like, we probably thought like, oh, well, we had passed, but so it counts like a gift on Monday. You know, it's just really what it counts, it's sort of updated it.
That's crazy.
I'm just happy for him and Charles.
Yeah, me too.
And so I should have taken this one.
What?
Looks like I should have taken this one.
She should have.
Let's see what I got back.
Okay, it must have been because I didn't keep it in there.
Maybe.
Yeah, all right, I just wanna make sure this isn't like this. comes
No,
separately.
I didn't get anything for that. You guys didn't get anything about exams off for next, for this.
So you feel relieved now?
Yeah.
Don't worry, Clara, I've been in your shoes.
But you guys just got hit hard bad. So,
Yeah.
But if I don't know. I'm saying this, if I don't pass it this time, I'm not coming back.
you should work with Carla.
Have you seen, did you improve?
No, I went down. My essays went up, my MPs went down.
Oh, okay.
It went down to 6.
Really?
But I've taken it so many times and I've been and I make 120,000 a year.
What?
I make
Wow.
really good money. I got 4 houses, so do I really wanna do this, you know?
Oh, I
So-
mean, that's great, you have all this in common.
So it's kind of like this is just a second career,
Yeah.
but it's not that I need it, but
How many times have you taken it?
oh my God.
This is the exam?
I've taken it 1, 2, 3, 4, this my fifth time.
Fifth time?
The first time I was going to Cal Southern.
Okay.
I don't even know how to pass that school. I didn't understand a word. So when I retook the class again,
Yeah.
then it finally clicked what was going on.
Well, that's
Because
good,
Cal
yeah.
Southern, it was closing down and the California bar was closing down. So they were just kind of just shoving people through, giving money and
Oh.
get out of here. And that's where Latoya came from. And that's where
Okay.
Gwen came from.
Right, I'll go get there, yeah. And Gina too.
And Gina was another one, because Gina and I were in the same